rights of the Jewish people and promote justice for all. We conduct legal advocacy, research, and education to combat anti-Semitism. As part of our mission, we empower students and victims of anti-Semitism by training them to understand their legal rights, and we educate university administrators and the general public on best practices to combat racism and anti-Semitism. I'm honored and privileged to introduce our featured speaker today, my father, Nathan Lewin. When it comes to the topic of religious liberty for Jews in America, my father is a legend. There is, I believe, no legal issue that has impacted observant Jews in the United States during the last 55 years that does not have Nathan Lewin's fingerprints on it. In 1972, when my father was only 35 years old, he authored the amendment to the Civil Rights Act that defined religion as encompassing all aspects of religious observance and practice. The amendment was necessary and significant because Jewish Sabbath observers were experiencing discrimination even after the Civil Rights Act had been enacted. Employers were refusing to hire Sabbath observers, claiming that they had nothing against Jews. It was just their religious practice that made them unemployable. My father's amendment made it clear that discrimination on the basis of religious observance and practice was also covered by the law. My father also drafted the comp time legislation that enables federal employees to observe the Jewish holidays without using up all of their vacation time. And he drafted what has become known as the first New York Get Law, which requires those who apply for a civil divorce to first certify that they've removed all barriers to remarriage. My father has argued 28 cases before the United States Supreme Court. Several of those cases have involved religious liberty issues, including the right Lubavitch to put up their large Hanukkah menorahs on public property, the right of Jewish servicemen to wear a yarmulke in the military, and the right of Satmar Hasidim of Kiryas Joel to create a special public school district in order to educate special needs children in their community. My father's defended the rights of military chaplains and police officers who were denied the right to wear the religiously motivated beards. He's defended the rights of Jewish prisoners who were denied kosher food and the rights of communities that have wished to construct an Eruv, a symbolic boundary that permits Orthodox Jews to carry on the Sabbath. And he's fought for the rights of synagogues that were opposed by local zoning authorities due to religious bias. The list goes on and on. You might mistakenly think that defending and protecting Jews from harassment and discrimination is all that my father has done professionally. The truth is that all of this work has been done in his spare time, pro bono. Nathan Lewin is primarily a trial and appellate litigator. He's a constitutional law expert, a criminal defense attorney, a master brief writer, and a persuasive oral advocate. My father began his legal career clerking first on the U.S. Court of Appeals for the Second Circuit and then on the U.S. Supreme Court for Justice John M. Harlan. He served in high-level positions in the Kennedy and Johnson administrations, in the Department of Justice and the State Department. His numerous high-profile clients have included Attorney General Edwin Meese, former President Richard Nixon, actress Jodie Foster, and John Lennon. His stories could fill volumes. We're looking forward to his sharing some of them with us today. 20 years ago, my father and I opened up a law practice together, Lewin and Lewin. Our firm has provided me with the unique opportunity to learn from a genuine master. And for that, I will always be grateful. So without further ado, I'm delighted to hand over this stage to my teacher, my role model, my law partner, my father, Nathan Lewin.
Wow, that's quite a tribute coming from a daughter. I guess it beats introductions that I've received elsewhere, sometimes by people who have read a kind of curriculum vitae or something, and it certainly is very, very much appreciated when it comes from your law partner. And it turns out if your law partner is your daughter, that's even better. Okay, my subject that I've been assigned to talk about is where is the Supreme Court headed on religious liberty? Now, just begin with the subject of religious liberty. Most people, if you stop them on the street, most Americans, and you say, First Amendment, what does the First Amendment protect? Particularly in these days when everybody is concerned about demonstrations, about, parading, about things that are written, people immediately will say, oh, the First Amendment protects freedom of speech, freedom of the press. Well, they're right, it does. But only after the first 16 words of the First Amendment. Most people don't realize that. The founding fathers of the United States, when they agreed that there would be a Bill of Rights and the first 10 amendments were put to the Constitution, started that First Amendment with the words, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. The very first of the rights in the First Amendment pertain to religion, establishment of religion, or the free exercise thereof. Now, I understand some people have asked, look, what is the Brandeis Center, which is concerned about campus life and anti-Semitism on the campus? Why does it begin a lecture series talking about where the Supreme Court is going on religious liberty? What does that have to do with the Brandeis Center? Well, that's like asking, what do cherries have to do with cherry pie? What do noodles have to do with noodle pudding? I mean, anti-Semitism, and particularly today, when the concern is about feelings, hostile feelings against Israel, are all based on the fact that the Jews are not just an ethnic group or a racial group, as some would say. Some of its adversaries have said in the past, racial, ethnic people, they're a religious, and they have a religious tradition. Our attachment to Israel rose out of 3,000 years of feeling that we have for Zion, religious feeling that we've recited in prayers, that people have given up their lives for to try to travel. Everything that the Brandeis Center represents really focuses in large respect on religion, because that's what we are. We may be an ethnic group, but we're also very much affected by our religious tradition. So therefore, it's of essential importance to see what the United States Constitution, as construed and interpreted by the Supreme Court of the United States, has to say about religious liberty. Aliza has given you some of the background of the kinds of things to which I have dedicated a large part of my professional life. And that's because as a Jew who was fortunate enough to escape to the United States at the age of 5 and managed thereafter in the last 80 years to not only succeed in the American milieu and rise very fortunately to government positions where I had great responsibilities, including the enforcement of the civil rights laws on behalf of the Black community in the South, which I very proudly did in the closing days of the Lyndon Johnson administration, but in which I have, as I guess Aliza summarized for you, had the good fortune to have clients for various problems, not religious problems, but various other problems, who turned to me and asked me for advice or representation. I, as an observant Jew during all these years, managed, because this is a country which recognizes religious diversity and respects religious observance, managed to do the things that I was able to do, to get courts, including the Supreme Court of the United States, to schedule arguments in cases that I had so that they would not interfere with Jewish religious holidays. The courts have immediately done that, and courts of appeals now recognize, and they send out questionnaires to lawyers telling them when they're going to schedule an oral argument to please specify any dates on which they cannot appear for religious reasons. So religion, in terms of my own experience, has been central in terms of my life as a lawyer in the United States. When I began practicing law in a private capacity after serving in the United States government, the Supreme Court of the United States was really focused of those two clauses that appear in the First Amendment, was focused overwhelmingly on the Establishment Clause. What is the Establishment Clause? It says Congress, all of the words of the First Amendment are directed to Congress. It's been long established and accepted that that is not limited to the federal Congress, but it includes every local government. Congress shall not make any law respecting an establishment of religion. And the Supreme Court of the United States in the early 1970s was really focused on that clause. There was a challenge to Sunday laws on the ground that closing stores on Sundays was an establishment of religion. And the court beat that back with an opinion by Earl Warren in which it said, well, that's a recognition really of the fact that Sunday is a day that is mutually accepted as a day of rest. But there was, as part of that litigation, a claim by Sabbath observing store owners in Massachusetts that they were discriminated against because if they had to close on Sunday, they would have to be closed 2 days a week. And the court took that very seriously. And over the dissents of Justices Brennan and Stewart, the court held that those particular store owners had no right under the free exercise clause of the First Amendment. If they were forced to stay closed 2 days a week, that was only because if they were able to be open on Sunday, said the court, they would get a competitive advantage. So in the early 1970s, the court was really captured by the notion of the Establishment Clause. It prohibited, at a term that I clerked for Justice Harlan, it prohibited the New York State Regent's Prayer, which was a non-denominational prayer of thanks at the beginning of every day in public schools where students were entitled to absent themselves. But nonetheless, the court said it was not the business of government to be writing and preparing prayers to be recited. And therefore, that was held to be unconstitutional. At the same time, or in that same period, shortly thereafter, when Warren Burger became Chief Justice of the United States, the court had a case which has gone down in the history of the First Amendment. One of the most important First Amendment cases, religion cases, a case called Lemon versus Kurtzman, in which the question was, could government funds be used to pay the salaries of secular teachers in parochial schools? 2 states had provisions under which the financial burden of secular teaching in private schools and private Catholic or Jewish, but mainly the cases involved Catholic schools, would be underwritten in part by government funds. And Chief Justice Berger wrote an opinion for the court in Lewin versus Kurtzman, in which he set down a three-part test, which the courts have purported to follow in years thereafter, in which he held that that was unconstitutional. I'll tell you that I wrote a brief in that case for the Orthodox Jewish community, in which I argued, and I maintain it to this day, that not only is it not unconstitutional to pay secular teachers in private religious schools, but that maybe the free exercise clause of the First Amendment says to a religious parent, you will not be penalized. You cannot be penalized because you send your child to a parochial school under the rules of your religious faith. And the state requires that that school teach math, foreign language, civics, history. Those are all state mandated courses. And there's no reason why the parent, a religiously observant parent, should be required to personally bear the cost of that education when his or her neighbor sends their child to a public school and pays nothing out of his or her own pocket for the very same education. The court has never accepted that proposition to this day. And it was rejected in Lewin versus Kurtzman. But that was a period of time in which the Supreme Court was, as I say, overwhelmingly emphasizing the Establishment Clause of the First Amendment rather than free exercise clause. The Constitution, after all, says that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And the question is that I think I would talk about in just a few minutes before we open this for discussion, that the court now, in more recent years, has begun realizing that this emphasis on the Establishment Clause rather than the Free Exercise Clause is mistaken. That those who claim that there has to be a wall of separation between church and state, that's generally the phrase that's used. It's not the phrase that the founding fathers used. Wall of separation does not appear in the Constitution. But those who want to be sure that there is never a penny of public funds spent on education or other facilities of religious institutions have claimed that there has to be a wall of separation. And that, I think, is mistaken. And I think recent cases of the Supreme Court indicate that the court has been rethinking that proposition. Not just the most conservative justices of the court. Some people claim that maybe Justice Samuel Alito, maybe Justice Neil Gorsuch, maybe Justice Clarence Thomas are all extreme right-wingers, and they want to help religion. They, I think, are joined in a lot of the attitudes now towards First Amendment and religious liberty rights, not only by Justice Brett Kavanaugh, but even by Stephen Breyer and Elena Kagan. And I submit that it was possible that Justice Ruth Ginsburg or Justice Sonia Sotomayor, who I might add, by the way, as a district judge, Justice Sotomayor, in a case in which I represented the right to put up a menorah in White Plains, New York, Justice Sonia Sotomayor ruled in favor of the right to put up a Hanukkah menorah on public property in White Plains over the objections of the town of White Plains. So we won that case before Justice Sotomayor when she was a district judge. And I think that today's attitude towards religion by justices of the Supreme Court has resulted in much more respect for religious observance. And let me turn for a minute to the most recent decisions. Here, during the COVID crisis, there were a couple of decisions by the Supreme Court that got a lot of publicity because the question was, could the state authorities impose more drastic restrictions on churches or synagogues than they were imposing on secular gatherings, which had the very same possibility of transmission of the virus as the religious gatherings. And there were, in New York, Governor Cuomo set up certain areas in which he essentially was prohibiting religious gatherings by Catholics and by Orthodox Jews, essentially by Jews in areas in New York. And comparable situations of gatherings for secular purposes were being permitted. That went up to the Supreme Court, and in a very highly publicized decision, Roman Catholic Archdiocese versus Cuomo, the court ruled that the state could not do that. That was also followed by a decision similarly in California and a suit against Governor Newsom. Now, the dissenters in that case did not deprecate the right to religious freedom. They didn't say, no, you can treat religion worse than anything else. They said on the facts of the case and in light of the circumstances that were presented, that maybe the restrictions were permitted. But I think the respect for religious observance that was shown in those cases was shared, I think, by a full Supreme Court. The times have changed substantially. There was a period of time, Alisa has talked about the fact that I drafted a provision of the Civil Rights Act that said that there had to be a reasonable accommodation to religious observance, except when there is undue hardship to the conduct of the business. 43 years ago, I argued in the Supreme Court for a broad understanding of that provision in a case involving what was then called Trans World Airlines, TWA. And in that decision, the court rejected, because that was a time when the court was totally captured by the Establishment Clause importance, by the importance of not having any assistance whatever to religion. And the court rejected a broad interpretation of that statute. And not only a broad interpretation, but they said that undue hardship meant virtually nothing, that you don't have to do anything almost. De minimis is what the court called it, in order to accommodate to religious observance. I think that was at a time when the court had decided cases that said any kind of financial assistance to religious institutions, to churches, was unconstitutional under the Establishment Clause. The cases were called Meek versus Pittinger and Woolman versus Walter. The court had decided those cases. A couple of years later, the court explicitly overruled those cases, Meek versus Pittinger and Woolman versus Walter. They said they're wrong. Those decisions are wrong. And their emphasis on the Establishment Clause was wrong. But the court still, unfortunately, has not corrected the error that I think was made 43 years ago in the TWA versus Hardison case that I had argued. I had hopes that this court, because of the recent decisions it had rendered in favor of religious liberty, would overrule that terrible Hardison decision. Because, quite frankly, that ruling that only de minimis accommodation has to be made has affected employees who are Orthodox Jews, who are Seventh-day Adventists, and even Sunday observing Christians. I had a case in the Supreme Court of the United States involving a Sunday observing Christian, who I represented. And Sunday observing Christians also would require an accommodation. And to say no, nothing more than de minimis is required is, I think, wrong. The court had, and here is something, if you're looking at where's the court headed? The court is clearly headed as it's presently composed. And I think the Chief Justice Roberts agrees with this, and certainly Justice Thomas and Justice Alito and Justice Gorsuch and Justice Kavanaugh. And I think the latest Justice Barrett, would agree with that too, that they're headed for greater and greater recognition and respect for religious liberty. But they had two cases on the docket this term in which they had an opportunity to overrule what happened in TWA and Hardison. And to those who watch the court's docket closely, as I do, and file friend of the court briefs, as I did in those cases, urging the court to take those cases and resolve them by overruling what they had done in the Hardison case, were encouraged by the fact that if you follow the court closely, the court's procedure is such that they have a conference on Thursday or Friday of certain weeks, and then issue an order list in which they rule on those cases and the petitions that are made to the court. 12 times, if you followed it, those two cases involving that provision of the Civil Rights Act and the possibility of overruling it were put over for further consideration. And those who follow the court closely know that even if a case is put over once or twice or three times, it means that the court is at work on something. Maybe they're going to take the case, maybe they're going to write an opinion on it even without a petition for certiorari. 12 times. And I thought that means they're going to write an opinion that's going to overrule this terrible decision of 43 years ago. And just recently, 2 weeks ago, they came out with a decision that they turned down those two cases, with only Justices Alito and Gorsuch dissenting from the fact that they turned those down. Justice Alito wrote a dissenting opinion in which he said he could not understand why the court would not take those cases. I can tell you, I can't understand why. And I can't understand also why Justice Thomas and Justice Roberts and Justice Kavanaugh and Justice Barrett didn't agree to take those cases and get rid of that terrible ruling that really totally undercut what the purpose was of that amendment to the Civil Rights Act of 1964 that protected religious minorities. I think my time for prepared argument is probably over, and I'd be very happy to answer questions and discuss anything else that has to do with the issue of where is the Supreme Court headed on issues of religious liberty. Alisa?
Yes, so we're going to bring back, there we go, me, and let's bring Ken Marcus also on. There we go. Ken is the chairman and founder of the Brandeis Center. And we thought we would have now a conversation to follow up. And I want to invite the members of the audience who are watching. If you have questions, please submit them either in the Q&A or the chat feature on Zoom, and we'll try and incorporate those into our discussion and ask those as well. So Ken, why don't you start us off?
Thank you, Elisa. And Nathan Lewin, what an extraordinary presentation and what an extraordinary career that your daughter has described. It is very much an honor to have you appear now as part of this series, as it has been a great honor to have you on our advisory board, and you have done great service to the Brandeis Center. It may be later in this conversation we'll touch on some of the other aspects of that service, such as a recent brief that I think was very important. But I'd like to ask you just a little bit, well, I guess I'd like to ask you a little bit about the way in which you see the trajectory of the Supreme Court on religious discrimination cases. I found it interesting that in describing the recent developments, you took what I would call a whole court view of the development, describing how the whole court may have evolved in its view of religious discrimination cases. Other commentators focus more on individual justices, and in particular, the appointment of Justice Amy Coney Barrett to the seat previously held by Ruth Bader Ginsburg. And other commentators would ask questions like the following: to what extent should we anticipate over the coming few Supreme Court terms that the court would revisit those issues on which there was a 5-4 majority, in which Justice Ginsburg was in the majority, and for which Justice Barrett might have a different perspective? That's something that I have wondered, and I'm not sure whether you think that that's even the right way of asking the question or not, in light of the way you focus not on particular justices and particular appointments, but rather on what at least I have thought I've heard you to describe as a kind of an evolving view, and not just the creature of changing personnel, but also perhaps of evolving understandings within particular justices who persisted. But either way, whether focusing on recent appointments or on evolution of views, to what extent do you see changes in determinations on issues for which the Supreme Court was closely divided with a different set of personnel?
Well, I'm glad you asked me about the late Justice Ginsburg and her views, because one thing I think is clear from history, really, is that Justice Ginsburg herself was very respectful of religion. Maybe it's not commonly known, but I litigated in the Supreme Court, ultimately up to the Supreme Court, the issue of whether a uniformed person, psychologist in the Air Force, had a constitutional right to wear a yarmulke together with his military uniform. I received a very surprising adverse ruling after I won this in the district court, an adverse ruling from 3 judges on the Court of Appeals, including, of all people, by the way, Judge Abner Mikva, who had been the head of the Jewish caucus in Congress. And I asked the full Court of Appeals for the District of Columbia Circuit to review that decision. 3 judges of that court said they would, indicating that they thought that the decision that had held that he did not have that right, constitutional right, was wrong. And one judge who wrote a very powerful, short opinion stating that this was disparaging to religion was none other than Circuit Judge Ruth Bader Ginsburg. And when she was appointed to the Supreme Court, President Bill Clinton announced in a press conference that that was a subject which he had discussed with Judge Ginsburg when he first met her after it was suggested that she be appointed to the court. So Judge Ginsburg, and ultimately Justice Ginsburg, was really very personally respectful of religious practices. And I might add that the other 2 judges who would have ruled with her were none other than Judge Antonin Scalia, who shortly thereafter became a justice on the Supreme Court, and Judge Starr, who, of course, later became famous as the special prosecutor in the Clinton matter. So I think that on the current Supreme Court, and even if Justice Ginsburg were alive today, there would be a very different attitude than there was in the 1970s and 1980s, when the court said, no, we won't allow any expenditure of public funds. Now, how does that affect, you asked, how does that affect other areas of the law where maybe Ruth Ginsburg was either in a majority or had a view that would be different from the view that is held today by Justice Amy Coney Barrett? I don't know. All I can tell you is it does seem to me, and maybe the cases, the particular cases I've talked about, where I hoped that the court would overrule a bad decision of 43 years ago, and it decided after 12 different times having it on its conference list not to do anything about it, that may indicate that the court is very sensitive now about overruling old cases. And it may be that this court as an institution under the leadership of Chief Justice Roberts does not want to be in the position of saying some old case that was decided years ago is now wrong. But I think that there are certainly at least 5 justices, and maybe 7, and maybe 9, who would agree that that decision was wrong. But the court does not want to be involved in overruling. So to that extent, I think that the individual justices and their attitudes have something to do with the direction that the court is headed in. Clearly, Justice Alito and Justice Gorsuch are far more ready to take on old bad precedents in the area of religious liberty than apparently the other justices are. I hope that answers your question.
I think it does answer the question. I mean, if I may follow up with a particular example, though. So, if I could suggest a Christian Legal Society versus Martinez, possibly the sort of case where authored by Justice Ruth Bader Ginsburg, but where a change in composition could possibly have a change in result. The case has been intriguing to us because of the clash between, on the one hand, Christian legal societies' interest in observing its own religious tenets in a way that precluded membership or office holding by certain individuals who don't share its views on marriage and other topics, versus the anti-discrimination principles of the universities. we've seen that case come up over and over again with university administrators who frequently feel that it protects universities in keeping out groups like Christian Legal Society that insist on ensuring that its officers and members share its tenets. On the other hand, we've seen University Council take the view that this does not apply at all to anti-Semitic organizations, even arguing that universities may not withhold sponsorship of anti-Zionist and anti-Semitic groups because of a free speech principle. It seems like there is currently a highly selective interpretation of that case, which I find a little bit complicated by the question of whether that case, if it appeared again before the court, would be decided in a similar way given the different composition of the court, and in particular, the instrumental place of Justice Ruth Bader Ginsburg in the initial opinion. So I just wonder if you have any thoughts on that, either with respect to the application of the case now, or of the likelihood that that sort of issue would be treated in a different way given the different views or composition of the court today.
Well, I think there's no question that on very specific, detailed questions like that, in which the applicability of very specific statutory requirements are construed and are decisive, yes, there's a possibility that the change in composition of members would result in some opposite outcome. On the other hand, so far as I can tell, this recent reluctance by the court to be overruling old decisions is maybe paramount right now. There is presently pending the Fulton case in the Supreme Court. No decision has been argued. And the case that involves the Philadelphia foster care, Catholic foster care service, which did not want to allow, and which said publicly that it would not place children with same-sex couples, and was therefore stricken from the list of eligible foster care services in Philadelphia, whether that's permissible. Now, that case was argued in the Supreme Court. It does raise the possibility at its broadest, and I will tell you, I wrote an amicus curiae brief suggesting it, saying that the court could use that case to overrule a terrible ruling by Justice Scalia in the Peyote case, which essentially said that the free exercise clause of the First Amendment was inapplicable if to any law that provided a neutral standard that one had to comply with. And the court could use that decision, and the petitioners made that presentation as one of the issues that is presented to the court, and said, look, use this vehicle to overrule the decision, the opinion that the Supreme Court issued in Oregon versus Smith, which was the case that did lasting damage to the free exercise clause of the First Amendment. Now, I don't know what the Supreme Court will do. If you read the transcript of the oral argument, there was almost no interest on the part of any justice to use that case to make that very broad ruling. When the court decides the Fulton case, it'll be interesting to see. I mean, I think the court will hold on the basis of the oral argument in favor of the Catholic foster care group. But they will do so, I would expect, on narrow grounds and not on the broad ground that they could use to overrule Oregon versus Smith. And I think that is because the court today is very skittish and very wary because of all the public opinion that is concerned that in the abortion area, they may overrule what has been, of course, a very established Supreme Court precedent. They don't want to be viewed as a court that's ready to overrule old decisions. Consequently, they step back, and Justice Roberts is a very, very careful lawyer. He can draw very, very fine distinctions, which frankly, to a lot of lawyers make very little sense, but nonetheless, he draws them in his opinions. So it's very possible that in terms of the Fulton case, they will decide it on very, very narrow grounds because they don't want to be viewed. And particularly now that everybody's talking about, we have to re-examine the court membership. There's a study as to what should be done about the Supreme Court. There's legislation that we should increase the membership of the court to 13 justices. I think the court is affected by that. It shouldn't be maybe, but nonetheless, it is affected by all this popular outcry.
You just now touched on what I was going to ask as my question. I was going to say, since this very interesting perspective of yours, where you seem to be saying that the court is very sensitive of not appearing too political, perhaps, not appearing like it's ready and quick to overturn precedent because of the potential criticism of the court as becoming a political organ as opposed to really carefully analyzing the legal issues. So what are your thoughts and reactions to these discussions now about potentially increasing the size of the court? What do you think of those proposals?
Well, I side with a very great Harvard Law School graduate called Stephen Breyer, who delivered a talk the other day that I watched as a Harvard Law School graduate, in which he said, you've got to be very careful when you do this. It's clearly, he said, he believes that this is a terrible idea. I think Ruth Ginsburg had expressed her view that it was a terrible idea. And I think that there was even a senator named Joe Biden who years ago said that is a disastrous idea. I think, the lessons we have of history when Franklin Delano Roosevelt tried to do this in order to achieve New Deal reform prove that it's a terrible idea. You may disagree with, you can have all the feelings, strong feelings you have about how the Republicans treated the possible nomination of Merrick Garland to the Supreme Court, and how Justice Amy Coney Barrett, who is, everybody agrees, is extraordinarily capable and was an appropriate leading candidate for justiceship on the Supreme Court. You can disagree with what was done to Garland. You can disagree with the fact that Justice Barrett was appointed, but I think that maintaining the independence and integrity of the Supreme Court is an essential part of the structure that the founding fathers of the United States brilliantly created with the US Constitution and with the separation of powers. And this idea is a terrible idea.
Ken, did you want?
Well, yes. It's not as directly related to religious freedom per se, but I think that you have eloquently explained the connection between anti-Semitism and other forms of religious liberty that have before the Supreme Court. Very recently, you generously provided an amicus brief on behalf of the Louis D. Brandeis Center urging en banc review of a case involving an effort by the state of Arkansas to restrict BDS activity by, I guess, government contractors of the state of Arkansas. I wonder if you could share a little bit of information about that. I thought that it was an excellent brief, and I think that our listeners would be interested to hear a little bit from you about the brief.
Well, it's well established by Supreme Court decisions, including those, I think, to which the most liberal members of the court assented, that the United States, in terms of its contracting, the government in terms of contracting with those with whom it enters into contracts, has the right to say, look, we don't want you to be, as a condition of the contract, we don't want you to be doing things, not saying, and not a restriction on what you say or what you distribute in terms of your views, but we don't want you to engage in conduct which will be contrary to American policy. Please sign that if you want to contract with the United States. And the Supreme Court of the United States has said, in a case that involved the NAACP, that to the extent that a boycott restricts speech as opposed to conduct, it might be prohibited or prevented by the First Amendment clause regarding restrictions of speech, that government cannot restrict speech, but limited to speech. So Arkansas, along with, I think it ended up being a total so far of 32 states, 16 of which had almost identical language in their law saying that state could insist that those who contracted with it would not engage in a boycott of Israel, engage in commercial conduct which would boycott Israel, because Israel is America's staunchest ally in the Middle East, no question about it. So you could say that that's a condition of the contract. It would not violate the NAACP case because it would not have to do with speech. And it would be consistent with the cases that say you can condition your contracts. Well, the people who opposed this anti-boycott, divestment, and sanction, anti-BDS legislation have sued in various states to declare it unconstitutional. I think it's clearly constitutional because it affects conduct and not speech. So what happened with a panel of 3 judges of the 8th Circuit in Arkansas, was that 2 of those judges said, well, we read an all-inclusive concluding words which say other actions as possibly including speech. And therefore, there's a basis for saying that maybe this law is unconstitutional. Well, that violates on its face 2 cardinal principles of statutory construction, which are that you don't construe a statute to create constitutional doubts. That's a principle of American Supreme Court law that goes back 150 years. Also, when you construe a law which has an all-inclusive concluding phrase, it relates to the same kind of thing that appears in the previous language of the statute. And here, 2 of the 3 judges, not all 3, because there was a strong dissent, but 2 of the judges said, well, we're going to read it as being speech. And therefore, the contracting party is prevented from speaking against Israel, prevented from writing anything that will be against Israel. That's not what the law says. So I agreed, as did many other, there were a lot of other friend of the court briefs written, to ask the full Eighth Circuit. The procedure is that if 3 judges issue a decision, you can ask the full court, that full circuit court, to reconsider the case. And the Arkansas Attorney General said he was going to file to ask the full court to reconsider the case. I wrote a brief very proudly for the Brandeis Center, which made those points and said you should reconsider it. And the court has taken the first step to reconsideration, because under the court rules, there may not be this in-bank reconsideration unless you give the other side an opportunity to respond to the request for reconsideration that the Arkansas Attorney General has filed. And he filed a very strong request for reconsideration. So the court asked for a request, and I think the people who are challenging that statute have now requested an extension of time within which to respond to the petition for rehearing and to the many friend of the court briefs, including mine, the Brandeis Center one, that were submitted in support of that petition for rehearing.
Excellent summary of a great brief and an important case. Aliza, I know that we are close to the 60-minute mark. I see that we do have a question from the audience. I don't know if we have time for that. It strikes me as being a useful question.
Yeah, I was going to ask. I thought we could just we could ask that question. I saw that one too, and then maybe if you could answer that. And what I wanted to do was maybe close out with, you have so many wonderful stories through the whole, this, 50 plus years of litigating on behalf of religious liberty. And some of those stories are really quite amusing and entertaining. And so I thought maybe you might pick one, maybe one of the yarmulke stories, and just to kind of close us out on a lighter note. So let me ask this question, and then you can address that and close us out with a story. So the question is, Justice Alito said that religion's becoming a, quote, disfavored right in certain quarters. Do you agree with him? And while the Supreme Court might be becoming more respectful of religion, is the public becoming less?
Well, the problem is that together with the great polarization that's been going on in American society and the enormous differences of view about various things, there has been no question a tendency to sort of stifle or reduce or suppress speech to some extent. And I think maybe those who support religious rights are viewed in certain quarters as being right-wing, being conservative. And to that extent, the media, I think, is less appreciative of the importance of religious observance. So I think it is true that if one views society from the perspective of the media, of what is the media saying, what do the newspapers, what do the news channels, the TV media, various platforms, what do they express in terms of American public opinion? It may look like America is turning against religion. I don't believe that if one really goes beyond that to look into the heart of Americans, I think Americans have always endorsed and supported religion. And my own experience is endorsed and applauded those who conscientiously observe their religion.
It's true.
So I take with a grain of salt
It's true.
the kind of media attitude towards religion, which I agree would support the conclusion that America is turning against religion. And I think is the basis for Justice Alito's statement that it's disfavored because the media make it appear as if religion is undercutting and preventing what are recently recognized constitutional rights, like same-gender marriage. And it's true that religions, very many religious precepts are not in sympathy with those views. But I think at bottom, Americans respect religion. Now, if you want stories, I mean, I love to tell, there are two yarmulke stories I tell, and I don't think we necessarily have time for both of them. But the yarmulke story that relates to the Supreme Court has to do with my case in the Supreme Court, in which I argued that a uniformed officer, uniformed psychologist in the Air Force had a right to wear a yarmulke. And I argued that in the Supreme Court, and an opinion by Chief Justice Rehnquist, who was not then Chief Justice yet, he was Associate Justice, but he was very strong during the oral argument and kept pressing me about the fact that the military was different, the military is different. And the Supreme Court ultimately wrote a 5-4 opinion, which rejected our position. Justice Brennan, joined by Justice Marshall, wrote a very, very powerful dissent. And at the end of his dissent, he said, because we had said in our papers that we were trying to get a law that would allow you to wear a yarmulke. So he said in the end of his opinion that he hoped that Congress would cure what the court was doing, because the court was saying there was no constitutional right, but Congress could require the military to permit it. And we did. Congressman Steve Solars, who was a good friend from New York and very supportive of religious rights, he and I drafted legislation which passed the Congress ultimately, but it only passed the Congress after we heard of a chaplain who had gone down to Grenada when the United States had its war in Grenada, very successful. And the chaplain had created a yarmulke made out of military marine material, camouflage material, sort of like this. And what happened was, we thought that's a terrific idea. And we sent this yarmulke, camouflage material, to the full Senate. Senator Lautenberg of New Jersey cooperated with us, and he sent it around. And lo and behold, after that was sent around, the Senate voted in favor of this law that had passed the House, because Congressman Solars had introduced it and it had passed the House. It ran into trouble in the Senate, but after this yarmulke was sent around, they supported the bill. So Congressman Solars sends a letter to Justice Brennan, saying to Justice Brennan, "Dear Mr. Justice, I just want to advise you that in line with your suggestion at the end of your dissent, Congress has enacted a law requiring the military to allow the wearing of neat and conservative articles of clothing pursuant to a religious observance." He sent that letter to Justice Brennan, and he sent me a copy. And in with the letter, as a PS, he said, "I enclose a yarmulke that we distributed to get the bill enacted. And he sent that to Justice Brennan. Well, coincidentally, just the week that I received a copy of the letter, I got a call from Justice Brennan's chambers that Justice Brennan had been invited to receive an honorary degree at Hebrew University in Jerusalem. And he had accepted that. And he wanted to talk to me. And I knew him from the time that I was a law clerk on the court. And he was really the most friendly justice on the court to law clerks and others. And he wanted to talk to me about who he should see in Israel and where he should spend his time during his visit. Would I please come over for lunch? He'll prepare a fruit salad in his chambers for me. He knew I was kosher. I did. I accepted Justice Brennan's invitation. And I went to see Justice Brennan, and we talked about Israel and who he should see. And at the end of the lunch, Justice Brennan says to me, by the way, Nat, you know that Yarmulke case you argued? I said, of course. He says, you know, I received a letter from Congressman Solars about it. And do you know Congress has passed a law that requires the military to allow you to wear a yarmulke? And I said, well, Justice Brennan, the truth is, I helped draft that law. He says, well, you know, in with the letter was a yarmulke made of camouflage material. And says Justice Brennan, my secretary brought in the mail that day. I saw the letter and I saw the yarmulke and I put the yarmulke on my head, he says. And that, would you believe it? I sat there in the chambers the rest of the day and I forgot I was wearing it. So I wore the yarmulke all day in the chambers. And that night, he says, when I left and I drove home, I came to the house. I was home for 5 minutes. And finally, my wife said to me, Bill, what do you have on your head? He says, when I left chambers, as a matter of fact, he says, I found out later that my law clerks saw me wearing the yarmulke as I was leaving, but they were too embarrassed to ask me why I was wearing a yarmulke. He says, I went home, and not till my wife asked me, did I realize that I was wearing a yarmulke. And he says, it was very comfortable. So I said to him, Justice Brennan, I suggest to you that you take that yarmulke with you when you go to Israel. You may find it useful. He said, okay, that's a good idea. Well, Justice Brennan never reported to me after he went to Israel. But months later, I heard from the man who ultimately was on the Supreme Court of Israel, Eliakim Rubinstein, who I had gotten to meet when he was the minister in the Israeli embassy. And he held very high positions in the Israeli government. And he's a devoutly Orthodox Jew, wears a yarmulke everywhere. He wore it when he went to the White House to see the president. He would wear his yarmulke everywhere. And Eliakim Rubinstein said to me, you know, Nat, Justice Brennan was in Israel getting his honorary degree. And I went over to him, and Rubinstein had a sense of humor. And he says, I went over to him. I introduced myself. I said I had been a minister in the embassy in Washington. And at that point, he was secretary to the Israeli cabinet. So I introduced myself to him. And I said to him, said Rubinstein, I said to Justice Brennan, you know, Justice Brennan, we're very glad to see you here in Israel. I'm very proud to be here because in Israel, you can wear a yarmulke anywhere, even in the military. And he says, when I said that, Justice Brennan put his hand in his pocket and pulled out this very strange camouflage yarmulke. And he said, put it on his head. And he said, me too. Now, I told that story a couple of times, by the way, with Justice Brennan in the audience. And he loved the story, I can tell you that.
Great.
It's a wonderful story, one of my favorites. So I thank you. I thank you very much for your time today, for your remarks today. It was a real treat and a real pleasure for us and for our audience. And we wish you continued strength, as they say, until 120 ad mea v'esrim. May you continue to help defend and protect the Jewish people. Thank you very much.
Thank you.
Thank you.